Hey everybody, how's it going? And welcome back to Copper Jacket TV. So it's very rare that we get back-to-back two-way wins, especially in the state of California, but that's what we have here. And this time, it didn't come from Judge Roger T. Benitez. This one came from a different federal district court judge, as a matter of fact, appointed by Obama. So let's talk about what's going on. Okay, so let's go and talk about what's going on here. So as I'm sure everybody watching this video knows, there are a lot of dumb laws in the state of California, and every year they seem to make more and more. Even if they don't make sense, even if they're unconstitutional, it doesn't matter. These people are just up there thinking of new ways to restrict pretty much everything that you do in that state. If you ever decide to dive down that rabbit hole, the only suggestion that I have for you is get a helmet, because it's a rough ride. Regardless, one of those laws that is unconstitutional, in my opinion, and dumb, is going to be a law that says if you've ever been convicted of a felony in any other state or anywhere in the world, really, and that felony was then overturned, expunged, removed from your record, whatever, California does not care. They don't care that it was overturned. They don't care that it was washed away. They don't care that it doesn't exist anymore. You have still lost your Second Amendment rights in the state of California for the rest of your life. So with that being said, there are several people that live in the state of California that had felony convictions in other places. For whatever reason, those felony convictions no longer exist, but they still can't practice their rights in the state of California. So they decided to sue the state. Now, this story, at least the one that I'm going to tell you, is absolutely wild, and you are not going to believe it, because one of the people who didn't have their rights while being in California was actually a cop for the last several decades in the state of California. As a matter of fact, he even had his COE, which was issued by the state of California. So we have a guy here that's a cop, that was an instructor in law enforcement, had his COE, but then after retiring and leaving law enforcement, he goes to try and get something personally, and he gets rejected. He's told, no, you can't own anything personally because of this law. So apparently in the state of California, if you are somebody who had one of these previous felony convictions that has since been overturned, you could become a law enforcement officer, you can train other law enforcement officers, and you could serve the state as much as you want, but the second that you are out of public service, you are now banned from practicing your Second Amendment rights. That is how absolutely nutty this entire thing is. So they decide to, again, sue the state of California and take it before the judge. Now, like I said in the very beginning, we're talking about an Obama-appointed judge who had some scathing remarks about the state of California and what they were doing here. So this is Judge James Donato, again, an Obama appointee, and he had some things to say about the state of California. Obviously, he had some things to say about James and being a law enforcement officer and everything else that the state of California allowed him to do while he was in public service, but he had some things to say about the other plaintiffs in this case as well. One of the things that he said that I thought was pretty pertinent here is that he said, the undisputed facts indicate that Linton and Stewart, the other plaintiffs, are also fairly described as law-abiding citizens. Linton is a veteran of the United States Navy with a clean criminal record for the past 37 years. Stewart has had a clean criminal record for the past 48 years, and California simply turned a blind eye to these circumstances and did not account for them in any meaningful way in its discussion of the constitutional right to keep and bear arms. So the judge is basically saying not only are they not considered felons anymore by the entire country and by the legal system itself, but these guys have been out of trouble. They haven't had any issues with law enforcement since that point, and in these cases, multiple decades that these guys have been exactly what, California says you're supposed to be, a law-abiding citizen, and yet California just simply overlooked that fact because of this law. And because of that, the judge decided to side with the plaintiffs and say that the plaintiffs have had their rights restricted unfairly and their rights are now restored. So the judge sided with the plaintiffs in this case, restoring the Second Amendment rights of these people. Now, here's one of the takeaways from this, okay? is that this only applies to these three plaintiffs right now. And while people might say, well, that sucks, it only applies to them, it would be nice if it applied to everybody else who had a similar circumstance. It does, in a lot of ways, apply to everybody else who has a similar circumstance, because all you had to do if you decided to challenge this in court yourself was simply point to this district court judge's decision as precedent for this particular matter. So where precedent didn't exist in California for something like this before, it does now. You can simply point to the same set of facts and circumstances that were used in this case to essentially win your case without there really being that much of a battle. Now, I, for one, have always thought stuff like this was absolutely ridiculous and completely unconstitutional. Losing your rights for life, your right to vote for life, your right to protect yourself for life. I mean, losing your rights for life for what amounts to non-violent felony, right? People, I mean, for instance, one of these guys, it was just a credit card fraud when he was a teenager, and apparently, according to him at least, it was an accident. But regardless, he pled down to a third degree with that particular judge, took that plea deal, served his probation, never got in trouble with the law ever again, became a cop, as a matter of fact. And so, that's that. But it doesn't matter to the state of California. It doesn't matter to a lot of states, as a matter of fact. But I have never understood how in this country somebody could lose their rights for life, while at the same time the court system, the judicial system says they're safe enough to be back out on the streets. If they've been released, they've done their time, their service, whatever it is, and their probation, and they've been released on the streets and they're safe enough to be around us and the general public, then they shouldn't have their rights restricted. That's just my own personal opinion where I stand on that. But again, it's nice to see a different judge view this under the light of the Constitution and in post-Bruin circumstances, where the judge even said that the state has not proved that there's a historical precedent for something like this to even exist. So this Obama-appointed judge used Bruin in his decision, but it's just nice to see it come from somebody else. I absolutely love Judge Benitez. I think everything that he does is pretty much great when it comes to this particular sphere, but it's nice to see other judges that are looking at the rule of law instead of their own personal agenda. So I wanted to share that with you guys. Thought it was fantastic. I do appreciate you guys watching. Please like, subscribe. You have a great day.